All rise. The Minnesota Workers' Compensation Court of Appeals is now in session. The Honorable Deborah Sutherquist presiding.
You may be seated. Good morning.
Good morning.
We are here this morning on the Faughn versus Northern Improvement Company matter, our file number WC 236525. Looks like we have Mr. Huber.
Yes.
Yes, representing the employer and the appellant.
Right.
And we have Mr. Burkett,
Yes,
and you're representing the employee today.
correct.
All right. You each have 15 minutes to present your argument. Mr. Huber, when you're ready.
Okay, well, just a quick housekeeping detail.
Yes.
If we may. I was discussing this with Jim Burkett outside. And a little unusual for us because neither side requested oral argument. And so it occurs to ask, would the court have interest in just asking questions? I mean, we read through your briefs and here's what we want to know more about. Can you tell me about this kind of a thing? I think we're in agreement that we wouldn't be opposed to something like that rather than trying to launch into some suddenly compelling oral argument. From our vantage point, the case has been kicking around for a while and it feels a little bit like beating a dead horse, frankly.
I understand that you are here for oral argument
Yeah.
today, and you've been ordered to be here for oral argument. I would like you to at least present your case, and then we will ask you questions while you're presenting your case.
Sure, okay.
As we typically would do. But thank you, Mr.
Yeah. And I'll try and streamline this and be brief. Three aspects of the case, three major aspects. Was this person hired in Minnesota, sort of the geography test? And is Northern Improvement to be properly deemed a Minnesota employer in this case? And then the third piece, was this man injured while he was working temporarily outside of the state of Minnesota? And of those three aspects of the defense, I think the one that we would like to highlight the most is the third one about temporarily working outside of the state, because he wasn't. Of course, all construction projects by their nature are going to be temporary. And you complete the project and you move on. But that's not the legally relevant consideration. The legally relevant consideration is whether he was temporarily working outside of Minnesota. And in this case, he was not. He was hired by a North Dakota employer to work exclusively in North Dakota and Wyoming. He was never going to be working in Minnesota.
So Mr. Huber, we can start the questions now.
Sure, good.
Okay, and so this was a question that I had for you. And I agree that reading the evidence, it was very clear that the employee was never going to be required to work in Minnesota, at least in the foreseeable future. Nobody had planned that. But does the statutory language require that any work ever be performed in Minnesota?
No.
So is it important then that he never did work in Minnesota if the statute doesn't require it?
Well, the additional criteria was whether we could establish a pattern that showed that each year he would be coming back to do this out-of-state seasonal work. And I think we did that because we showed that he was working for this company called Knife River.
But that was a prior employer, right?
Right. But in the asphalt trade, and this was his MO. He would complete the season and he would come back for the next year. And it was anticipated that that was what he was going to do with Northern Improvement out of the Dickinson office, working in North Dakota and Wyoming.
And maybe I didn't see it in the evidence, but was there any job offer or kind of off-season work that he was going to do or start date for the next year that was ever discussed?
Well, I think what was discussed was that they liked his work. They were anticipating him coming back. He wanted to come back, but that, of course, the work injury interfered. And so at that point, that changed the equation. And no, we did not get into a job offer situation.
So it was possible that he could return the next season, but not for sure.
Oh, I think it was highly likely. Everybody wanted him. He wanted to, and the employer was satisfied with his work. So that was clearly the intention of the parties.
I have a question for you. If he had been hired because he was a union employee, member of the 49ers here, located in St. Paul, if he had been hired normally, as I understand unions go, you're on the bench, he's up in northern Minnesota, and had he been hired out of the union hall on the bench for a position with Northern Improvement, which was part of the union contract and contractors in North Dakota, is that there wouldn't be any doubt that he would have been hired in Minnesota, would there?
Well, there's two aspects to that in this particular case. There was where he's physically standing. His testimony was that he was at his brother's farm in Bemidji.
And then that was both talking with Mr. Cornway, the supervisor, and also the superintendent, Corey Moult, correct?
And then there's the final assent part of that consideration, and the case law talks about that too. And the trip out to Custer, South Dakota, where he met with the job supervisor and went through the final paperwork and the final hiring process from our vantage point.
But there's case law that says that's neither here nor there, for want of a better legal term.
Well, first of all, we did not accept necessarily that he was physically standing at his brother's farm when he made that phone call with the employer. And then alternately, even if he were to be found to be there, it wouldn't be dispositive because from the vantage point of the employer, this hiring process wasn't completed until they were out in South Dakota.
But it appears that the compensation judge determined that either inferred or was informed by the testimony of the employee that he was in Minnesota and accepted that testimony. Fair?
At the same time, I had very strong circumstantial evidence that that's probably not the case because they asked him to submit additional information as part of this hiring process, and he explained he wasn't able to do that because he was traveling to visit family.
So in other words, you had credibility concerns regarding the employee's testimony.
I'm sorry.
You had credibility concerns regarding the employee's testimony that he was standing at the farm in Minnesota.
We found that aspect of the testimony to be very questionable and frankly unreliable.
Okay. Then why didn't you cross-examine him at hearing?
I think we did.
And Mr. Huber, your witness, I believe it was Ms. Schoenberg, if I'm pronouncing her name correctly, she testified that the employer had no idea where he was when he received the job offer. So was there any other evidence that he might have been somewhere else at the time he accepted the job offer?
Well, yeah, it puts us in a difficult position of trying to prove where he actually was. But other than the statements that he made to us at the time, which was that he couldn't respond because he was traveling to visit family, we didn't have anything else to go on. And so that was the extent of it from our vantage point.
Mr. Huber, I have a question about that hiring date. It appears in a number of exhibits, and I'm not sure which ones, but I do remember looking at them. There are varying dates of hire. I would imagine that is something that the employer inserted on those documents. Do you know what I'm talking about?
Yes, and I think we tried to address that at hearing, and Ms. Schoenborn eventually explained each time, I think, that from the HR standpoint, that the formal date of hiring was when they got together out in Custer, South Dakota. Was it May 19th? The exact date escapes me, but from the vantage point of the employer, that was the date.
And that was because, what was the rationale behind her testimony that was the date of hire?
Well, there was no assent by Northern Improvement until they got together out there and everything looked to be okay. In other words, conceivably, you could put yourself in the shoes of the Northern supervisor. You show up at this campsite and there's a trailer, and suddenly there's the unmistakable waft of marijuana vapor coming, or somebody has alcohol in their breath, or their eyes are watery and they're slurring their words, then we don't have an employment contract. You're not hired. So, that's where the employer's coming from in a situation like this.
I also had a question, because in terms of I think there were some discovery requests for admission, and your client indicated that Mr. Faughn's workplace injury took place in Wyoming and was accepted by the North Dakota WSI, when WSI stands for Workforce Safety and Insurance. Yet within the exhibits, there's a letter dated November 1, 2019 to Mr. Faughn from the WSI indicating that this notice is to inform you of Workforce Safety and Insurance's decision to deny benefits. Can you explain for me how, on one hand, it says his claim is accepted, and yet it seems that there's a denial here?
No, I can't explain that. I'm unaware of that until you just mentioned it.
And then also, there seems to be this kind of flavor throughout the course of the testimony and some evidence that North Dakota is ready, willing, and able to pay Mr. Faughn for this work injury that he had. Is there any letter or other evidence that is in the record before us that can show us that this claim is going to be paid by the WSI?
Oh, well, we have the testimony of Ms. Schoenborn that it's unequivocal that the employer is ready, willing, and able to administer this under their North Dakota insurance policy. Well, once we get a ruling, but at this point, with the employee filing in Minnesota and these proceedings pending, we can't get any action going in North Dakota.
Well,
under the North Dakota program.
Well, the North Dakota program is a state-run system, correct?
Yes, I believe that's right.
And it's a monopolistic system, so Northern Improvement has to go through the North Dakota system, as I understand it.
Okay. I'm not fully conversant with the North Dakota system.
So I'm wondering, is there any testimony from Ms. Schoenberg where she has discussed with the WSI that this claim is going to, regardless, is going to pick up and pay for Mr.
Judge, I think it's just been a given throughout that as soon as we get definitive ruling on jurisdiction, then the wheels will start to turn. And if they're to turn on the North Dakota side, then that's what's going to happen.
Yeah, because again, just like the letter of denial, there's a letter from to Northern Improvement, it appears like, or a statement from the WSI dated October 30, 2019. Mr. Faughn was injured on October 3rd, 2019, had a medical care and treatment at Casper Medical Imaging, and WSI denied that medical treatment in the record. So I'm having a hard time believing that they're just going to pick up and pay after a denial, not only of the claim, but also of the medical payment for the initial.
No, it's my understanding that there's no basis for a denial. Admitted injury.
Mr. Huber, I'd like to ask some more questions about the temporarily outside of the state discussion that you started with, saying that was your strongest argument. I'm going through the case law and trying to figure out exactly what this means, because, I do find your argument in your brief interesting, which is that if somebody's going to be temporarily outside the state, they have to be in the state at some point during the employment, and so that they can leave and temporarily work outside and then come back. However, our case law, at least in work comp, on the Work Comp Court of Appeals, is that oftentimes includes seasonal work when the employee really doesn't ever come back to the state of Minnesota. But those are work comp decisions. Do you know of any Supreme Court decisions that may address the temporarily outside of the state, including, for example, the Fisher case, which is, I believe it was cited in your brief?
And there's the Stenberg case that indicates that seasonal employment can be permanent employment if it's intended that the seasonal duties continue during successive seasons. And so a big part of our argument is that is indeed what we have present in this case. And the comp judge just missed it. She just, for whatever reason, she missed it. And so
So your argument is that he is permanently outside of the state of Minnesota. There's no temporary about it.
right.
Okay.
And so, Mr. Huber, I have a follow-up question on that. I read the cases as, the WCCA cases as saying seasonal can be temporary, but also in cases where there's no permanent work situs. Somebody finishes a job, they get transferred somewhere else, and they don't have a permanent work situs. And would you agree in this case, there was no permanent work situs?
Well, not entirely, because the case that seems to get cited to the most is that Faughn case where the fellow worked for Target and they had him installing fixtures at all these different Target stores scattered all around the country. We don't really have that here. We essentially have North Dakota and Wyoming, and we have this reciprocity agreement, and we have coverage in North Dakota, and we have a clear, unambiguous understanding that this guy's going to be working in North Dakota and Wyoming.
And so I think this is analogous to Faughn because a project is finished and then he gets assigned somewhere else. And I think if my memory is correct, there were maybe 5 different work sites, work projects that Mr. Faughn was on. And you indicated 2 states, but does it matter how many states it is if the work situs is never permanent?
Well, I think the concern in Faughn was that this person was going to be without a remedy or something like that, or just was willy-nilly or arbitrary in some fashion, and we don't have that here. In a sense, we have a single entity, this North Dakota WSI piece, almost like a single state. So we don't have those sorts of considerations and policy concerns present in this particular case.
But shouldn't the 2 fact scenarios that are very, very similar be treated the same regardless of whether there's a safety net of another state that arguably could pay benefits?
Well, I think the other difference here is that he was going to be returning year after year to do this same work with this company in this same physical locale. Very distinguishable from the Target situation.
Well, let me ask you again, because there's a letter from the WSI and Mr. Faughn dated October 9th, 2019, where it says WSI has determined you, Mr. Faughn, are a seasonal employee and needs to determine your seasonal average weekly wage. That goes on. North Dakota workers' compensation law defines seasonal employment as occupations that are not permanent or do not customarily operate throughout the entire year. Seasonal employment is determined by what is customary with respect to the employer at the time of injury. So we have at least something from North Dakota that says Mr. Faughn is a seasonal employee and not a permanent employee, just based on the occupation of being an asphalt worker.
And it was admittedly seasonal. Asphalt is weather related, can't be too cold. And when they're laid off at the end of the season, they can collect unemployment benefits in North Dakota. And they don't need to reapply to Northern Improvement the next year. They're still attached to Northern Improvement and they have the job to come back to, that sort of thing.
And I think the testimony from Mr. Faughn is he has not received any unemployment. Is that your understanding?
Correct.
And it's my understanding, looking at the record, Mr. Faughn hasn't been paid any type of workers' compensation benefits from the date of injury to present.
That's correct.
And that would include any payment toward his medical benefits.
That's correct.
Thank you.
Mr. Huber, you have exceeded your time. However, I do have one more question I'd like you to address, and that concerns the third issue that you haven't discussed yet, the Minnesota employer.
Yeah.
And could you just make some comments about
Sure.
that before we?
Well, in a given case, take for example, we know that there were 2 leased gravel pits in this case, one in Felton and one in Sabin. And Northern Improvement has some Minnesota people that they've hired in Minnesota to work at those leased gravel pits. And so if there's a mishap with those people, then in that case, with that sort of profile, then Northern Improvement is properly deemed to be a Minnesota employer. Don't have a problem with that. We don't have that here. He was not hired to work at the gravel pits. He was hired, and the employer has different departments. They've got Fargo, they've got Williston, or they've got Bismarck, Williston, and Dickinson, and he was hired to work exclusively with the Dickinson division. in North Dakota and Wyoming. So from our vantage point, it's not proper to deem Northern Improvement to be a Minnesota employer in a case with this kind of profile.
All right, I have no more questions. Judge Christensen?
No, thank you.
Judge
No,
Carlson?
Thank you.
Thank you, Mr. Huber. Mr. Burkett, when you're ready.
Good morning, Your Honors and Counsel. I have prepared my remarks to go in chronological order, based on the elements of 17604.1 subdivision 3, but of course I trust that the court will guide me to the specific issues where they have additional inquiries or questions. Of course, our position is that the findings of the compensation judge should be affirmed as being in substantial accord with the law and the facts. In this case, we believe that the facts support that Mr. Faughn was hired in the state of Minnesota for purposes of the case law. As we know, the situs of hire in Minnesota is determined by common law contract principles, and the general rule is that a contract is deemed to be made at the place where the final assent is given. And the compensation judge had an opportunity to judge Mr. Faughn's credibility. She also had, as part of exhibits, his deposition testimony, and she found him to be credible.
Mr. Burkett, before I go on, I do have questions about the offer and acceptance. Let me ask you this. Besides Exhibit D, which is the August 2020 deposition, I think it was Bate Stamp 36, maybe page 26 of the deposition, and I might not be exactly right on this. Where else in the evidence does it talk about where your client was when he got the actual job offer and accepted?
Well, it seems to me that there were essentially, I'd say, three components of the hiring. The first was the call he received from Northern Improvement after he submitted his online application. He received a follow-up phone call. It's our position that Mr. Faughn was in the state of Minnesota, that he had not left to travel out of state. And as was stated in the appellant's oral argument, the employer witness admitted that she didn't know where he was, and there isn't any evidence to suggest that he was outside the state. And then the third component was, and this is what I believe the compensation judge looked at, is he, after traveling out of state, returned home and submitted the additional paperwork that the Northern Improvement was looking for. I think, without going too far afield, the employer witness, Ms. Schuenborn, was consistent in stating that Mr. Faughn was offered a job over the phone contingent on that past drug test. The drug test occurred in Minnesota. And then the compensation judge, I guess there's a fourth factual element that she relied upon, is he made significant preparations to leave the state of Minnesota, getting a trailer ready, making custody arrangements for his two kids who reside in Minnesota. And when he, so in his departure of Minnesota, all those facts she felt made the final assent in Minnesota. And I believe that's consistent with the case law. So when he arrived in Custer, South Dakota, is where he met his crew. The exhibits and the testimony, the type of forms the employer had him fill out were all, administrative types of forms, like a W-4. I think he had to like sign an acknowledgement of a drug policy and kind of like an employment manual. And then, I apologize. And then the testimony of the employee was essentially he had to get together with the crew, met the people, and so there was no, the cases before this court, the factual, the hiring process, of course, is different for every employee and kind of every employer, but in this case, there was nothing significant that occurred when he arrived in Custer, South Dakota, other than just taking care of some administrative details, meeting the crew, and then he went right to work. So I realized I went a little far afield.
Sure, no, and I appreciate that. And I think your client's reliance on the job offer is clear by the preparations that he had to make. But I just want to shift it a little bit. Mr. Huber in his brief talked about the intentions of the party, or specifically the intentions of his client, and whether they intended to kind of take on Minnesota jurisdiction. And certainly things are different now with Indeed and online and cell phones, and where things physically happen is probably different than in a lot of the older case law that we have. So my question for you is, do you think that your client's intentions are important? And if so, how does that factor into the legal argument?
Sure. In terms of the hiring process generally, I would say I am aware of at least one case that's come before this court where it involved a North Dakota employer, and it was clear based on the facts in that case how they structured the hiring process was quite a bit different. Essentially, there was an online process, but then they had the employee travel to a site in North Dakota to really kind of complete the additional steps. And so I believe that, of course, shows that North Dakota employers are generally, I'd say especially medium to large employers are generally cognizant of the monopolistic nature of North Dakota work comp and various entanglements. And so I'd say in this case, I think it's interesting. I mean, he had his drug test in Minnesota. All the key components occurred within this hiring process in Minnesota. And then I think that this is the kind of case, in my brief, I did discuss public policy considerations where essentially you have an employee who, union worker, he had never worked for Northern Improvement in the past. When this employment contract was formed in Minnesota, he could not have, I think, reasonably have thought, what about next season? What about the following season? It was really, I think most employees, their mindset is, hey, I work, I have my union scale job. I want to see what it's like working for this company. And I think the alternative or the reverse is true for the employer. They don't know what skills or what kind of employee he would be. And it turned out that, he was a good worker and there was a good relationship, but it was a brief relationship before Mr. Faughn sustained his devastating work injury. I believe it was approximately 4 months. And so I think the public policy considerations and the case law really are set in place, to protect someone, a Minnesota resident, in this type of circumstance.
And so it's true, he hasn't received any type of workers' compensation benefit from Wyoming, North Dakota, or Minnesota as of today.
That's correct, Your Honor.
And the injury happened in Wyoming. I assume he has not made any claim for, filed the first report of injury or any claim for workers' compensation benefits in Wyoming.
That's correct. It was there was that reciprocity agreement in place, but I believe it was actually the employer that initiated that process, is my understanding, in North Dakota after the work injury occurred. But I think it does also highlight, some of the issues here when we're talking about temporary employment, and whether or not the situs of his employment, where it was created, because the contract was formed in Minnesota. When you talk about, okay, was the situs, did it transfer outside the state of Minnesota? I'd say, of course, no. But the other question is, well, which state did it transfer to? I mean, he's injured in Wyoming. He bounced back and forth between Wyoming and North Dakota, and the appellant argued in their brief, essentially, that we should treat North Dakota and Wyoming as essentially one jurisdiction because of this union reciprocity agreement. But my response would be, well, as we all know with union agreements, there's some degree of speculation on top of the fact that North Dakota and Wyoming are clearly two very different jurisdictions. There's nothing, there's no indication that could change in the future. So I think that's the pitfall of trying to use a union contract to essentially combine two foreign jurisdictions.
Along the same line of the same question I asked Mr. Huber, have you had any contact from the WSI indicating that this claim is ready, willing, and able to be picked up, and there's money for his wage loss, his medical benefits, and rehabilitation care and the like?
To my knowledge, my office has not received any correspondence from North Dakota WSI, the state. Just to clarify too, I'm not licensed to practice in North Dakota, but my understanding is we have not received any paperwork from North Dakota.
And I assume that would also apply your client would, if he had received any information from the WSI regarding benefits, he would share that with you.
That would be my understanding. What we have is essentially what the appellant put in as evidence at the hearing. Those documents is to the extent of our file.
Mr. Burkett, I have a follow-up question on the union contract. And I'm certainly not an expert on union contracts, but I would like your opinion on this. Even if the union contract did give themselves jurisdiction in North Dakota, does that somehow trump Minnesota law that would give jurisdiction to your client?
No, I would say that the statutes and case law, as I interpret them in Minnesota, and whether there's of course there's case law that addresses essentially can an employee in another state essentially contract out of work comp, and whether somehow Minnesota would be bound by that. And as far as I'm aware, that's still the case. The Minnesota workers' compensation program is not in any way hindered from paying benefits in a situation, whether it be a union or like a private disability policy.
If we reverse and decide that Mr. Faughn was an employee in North Dakota entitled to workers' compensation benefits, is it possible that they could deny the claim because they haven't received anything from them? And if so, then we're left with, as you indicated earlier, Minnesota resident with admitted injury with no recourse at all at that point, because we've denied, apparently North Dakota has denied an early letter and nothing's been filed in Wyoming.
Well, I think I don't know enough about North Dakota WSI to be able to say definitively, to speak as to whether the claim would be accepted or not. But yes, I think that goes right to the public policy. Excuse me, I apologize. The public policy considerations, and but I think essentially in a 4-month employment stint. There was nothing that our position is that would have taken that out of the realm of temporary and made it permanent. In any discussion about future successive seasons is really pure conjecture, especially given he's a union employee. He was a union or is a union employee, and we know they tend to move around.
Thank you, Mr. Marquette. Any other questions? Judge Christensen?
No, thank you.
Judge Carlson?
No, thank you.
Thank you.
Thank you, Your Honor.
Thank you for your time today, gentlemen. The record is now closed. We have 90 days to issue our decision, this matter, and we are now in recess.
One additional housekeeping detail,
Yes.
since I have you all here.
Yeah.
We received the notice of the oral argument around November 1st, I think we were talking about that, and today's the 20th. And I was set for a hearing in another case today at 9 o'clock with Mr. Scully. And as I'm sure we're all aware, the state has a really good system right now with a workers' compensation calendar that lists all the cases and all the attorneys that are assigned to the cases, so that we don't get double booked like we used to. And so it was startling to me because I just don't get double booked anymore because the clerks do such a good job with this system. And Mr. Burkett and I were puzzled at the outset why we got this letter, and we thought, oh, maybe it's a mistake. And that's another reason I thought it might have been a mistake, because I'm clearly set for a hearing at 9 a.m. at OAH, and yet here I am getting this notice from the Court of Appeals for an argument at 10 o'clock. Do you know, is this court tied into that calendaring system so that you can coordinate like that, if you know? It's a problem for me because I have young people at my office that I can assign things to when there's a conflict.
Mr. Huber?
But I can't assign them to this, and I probably shouldn't assign them to a hearing with Mr. Scully.
Mr. Huber, thank you for your comments. We will definitely take them under consideration and we'll check into it.
Okay,
So thank you so much.
you're welcome.
All right. Well, thank you, gentlemen.
Thank you.